Hi, I'm Jerry Sparks, President of AG Financial Insurance Solutions, and we have again with us Rich Hammar, renowned attorney for the General Counsel of the Assemblies of God, diesel mechanic, all sorts of other talents that you may not know about. But we're here for Risk Management Live, and boy do we have a subject today, because this is something that any nonprofit that takes trips really needs to know about, and that's assumption of risk forms. So there's many churches, schools, and charities that take trips, and a lot of times they're going to have somebody sign what is called a release. And some of these releases work, and we've seen court cases where releases don't work. So let's just talk a little bit about what a release is, and go ahead and define what a release is and what really makes up a release, and why they work or why they don't work.
You know, Jerry, you're absolutely right. This is one of the most important topics that we've covered on Risk Management Live. When you think about it, I don't know of a form, or at least there wouldn't be too many forms, that are more commonly used by churches, schools, charities, recreational venues than what we might call release forms. They're ubiquitous. But let me start by talking about definitions. People often use these terms interchangeably: release forms, waivers of liability, exculpatory languages, assumptions of risk. And certainly release forms and waivers of liability and exculpatory clauses are all alike in the sense that somebody is purporting to release a church or other charity from all liability. It's a universal affirmation of release. An assumption of risk form is a little bit narrower or different in the sense that it involves a person assuming specified risks. So that's the definitional component. Now, in terms of the legal requirements for a valid release, let me just make a few general observations about this. Of course, there have to be two contracting parties, and there is also the necessity that the form be supported by the legal doctrine of consideration. In any contract, to be legally enforceable, each party must make a commitment, a promise, and must receive something of value in return for that commitment. So in a release form, what's going on? You're promising, you're affirming that you're going to release the church from liability for your death or your personal injury that may occur because of the negligence of the church. And to do that, that's a very valuable commitment on your part, and you need to receive something of value called consideration to support that or to make that promise legally enforceable. And so, Jerry, what I see happen, I did a brief review of, I decided to look at reputable public universities that typically send groups to other countries oftentimes, and I looked at a number of these releases, and it was amazing to me how many of these releases were legally invalid because they failed to identify consideration. So here's an example of one from a reputable college and university that you would be familiar with. I agree for myself, my heirs, and my personal representatives to release the college and its trustees, agents, employees, and student leaders from any and all liability for damage to my personal property or personal injury of any kind, including death, et cetera, et cetera. But notice at the beginning it says, I agree to, on behalf of myself and others, to hold the college immune from liability. There's no consideration there. Now contrast that with another public university that has participants in university-sponsored trips sign this: in consideration of my participation on the trip, I hereby accept all risk to my health and of my injury and death that may result from such participation, and I hereby release the university, its board, et cetera, et cetera. Look at the first phrase, in consideration of my participation in the trip. So that's the standard way that it's done. And then, of course, the agreement and some other contractual requirements for a valid release are that the terms need to be sufficiently definite. You don't want it buried in the legalese of the rest of the agreement. I see these all the time. You have to search to find the language of release. That is an unenforceable release. It's got to be set off. It's got to be bold, emphasized, larger font, all caps. That's what needs to be done to draw people's attention to it. Otherwise, you run the risk of a court not enforcing it. You have to be sure that there's no legal prohibition against against the agreement, the release that you're proposing. Now, what does that mean? Well, there's some things that the courts have said render a release invalid. And those include an attempt to relieve a church or other charity from liability for their gross negligence. Gross negligence borders on reckless behavior. Another one that many courts have recognized is what you might call an adhesion contract. And that simply means a gross disparity in bargaining power, where one party has all the bargaining power, the other party is a take it or leave it form. You can't make any modifications to it. Those are often thrown overboard because the courts have said there's no mutuality of assent. And a perfect example of that, Jerry, was the Hotchkiss School case. Hotchkiss School is a private school in Connecticut that sent a group of kids, minors, to China a couple of years ago. One of those children, she was a 15-year-old girl, was severely and permanently injured because of contracting a disease from an insect. I think it was tick-borne encephalitis. And she recovered a $42 million verdict against the school for its negligence. They hadn't checked the CDC website to look at threats around the world of disease. There were a number of other things they did the court found to be negligent. But the important thing I want to mention here is that the female student who was 15, her parents signed a release form on her behalf. And the court summarily dismissed the relevance of that form for two reasons. Number one, it was attempting to release the claims of their minor daughter. She, a 15-year-old, anybody under 18 has no contractual capacity. They cannot sign a valid contractual agreement, including a release form. So the parents did on her behalf. In the overwhelming majority of states, I think there are just a couple of exceptions, parents cannot release the claims of their minor children. They can release their own claims to the loss of society, the mental anguish they suffer, but they can't release their children's claims. The second thing about that release that made it unenforceable was this concept of adhesion contract, of unequal bargaining power. And the court noted that those parents had no right to modify that agreement, to say, we don't like this provision or we want to amend this provision. They would have been totally rejected by school officials. You take it or leave it. And that's another reason that release form was found to be invalid. So again, it's very important that you make sure that language is clear and unambiguous, bold and highlighted, set off, and that there is an opportunity for negotiation of terms rather than one person dictating all the terms to the other. And just to sum up, let me also mention this. I can't stress this enough, that the courts abhor release forms where you are trying to relieve yourself of liability for death or injury to an otherwise innocent person because of your negligence. That just, it cries out as unjust. And so the courts do anything they can to reject these. Do not think your release forms that you use are going to be recognized as valid by the courts. They will leave no stone unturned in trying to rule that release form to be legally invalid and unenforceable. The requirements for a valid release form are strictly construed, and you must be absolutely certain. Now, what does that mean? You don't rip it off the internet. Oh, look at this release form here. I found this on the internet. And think you're going to apply that to your situation. It may work, it may not. There was a case in Tennessee where there was a release form signed by a parent, and this parent was involved in a school-related activity, was injured very severely, and the release form, everything, the parties were in Tennessee, the injury was in Tennessee, but the release form the parent was required to sign listed California law as the applicable law. Why was that? And that came as a point of confusion to the court. You know, why would they select California? Well, they selected California because that's what the form said that they ripped off the internet. And without any legal scrutiny or evaluation, nobody caught that. And so California law had to apply to that situation. Now let's conclude with this one other point. And we've alluded to this before, Jerry, but that's minors. What do you do about minors? And I think it's so important you understand the general rule that's almost universally applied by the courts in this country, that a minor, anybody under 18, has no contractual capacity. They cannot enter into enforceable contracts. They have a legal incapacity, it's called. And so parents often are asked to sign releases releasing their children's claims against the church or charity. Those don't work. But that doesn't mean you don't do anything. I think it's very important that you have parents sign a parental consent form that does a number of things. It includes the parent's consent to their child participating in a specified activity. It lists any medical allergies or conditions that may be relevant in the event of an injury. Number 3, it identifies somebody who can make emergency medical decisions in the event the parent or guardian cannot be contacted. Those are some of the very important things. And the parent identifies activities they do not want their child to participate in, most significantly, swimming. Can your child swim? Yes or no? That's an essential question you must ask. So those are some of the things. And here's another one. I get asked this all the time. Should the form be annual or per project or per trip? And I think it's very important that it be on a per trip basis.
Great information. You know, I actually, because of the case, the Hodgkin's case, we actually changed a lot of our forms by putting in the specific activities that people would be doing at camp. So one of the things that you need to realize is that there, number 1, needs to be consideration. Number 2, you need to define the activities that people are doing so they know exactly what activities that they're signing off on. Number 3, have a place where we do not authorize our child to participate in the following, so they have a chance to sign off on it. The medical questionnaire, if your child has anything wrong, has any medical issues, that the people know about that. And then actually have a medical treatment authorization form, so if the child does get hurt while on the trip, they have the authority to actually get them medical treatment.
And Jerry, that's for children, but keep in mind, many churches send adult groups on short-term mission trips in this country or abroad. And that's a whole nother issue. And that would be more appropriately probably an assumption of risk form. Adults can assume known risks voluntarily. So those risks have got to be specifically identified. And it should say these known and unknown risks associated with this, and those would include in foreign countries oftentimes lack of medical facilities or services. So adults can sign assumption of risk forms. They are more likely, much more likely to be affirmed and applied by the courts than parents trying to release a charity for injuries to their child. So that's very important that you consider an assumption of risk form. Adults have the right to assume risk. When you're sending groups to third world countries, there's a lot of risks, and adults are able to assume those risks. And that swerves into the related issue of extraterritorial insurance coverage. Your insurance policy probably does not have coverage for injuries that happen on these out-of-the-country trips.
You're absolutely right. So actually you need to make sure that you do buy coverage, your church is buying coverage to protect the church, or your charity needs to buy coverage for foreign liability and foreign automobile liability if you're traveling via automobile in those countries. So
and having them sign the assumption of risk form.
And having them sign the assumption of risk form. And I will tell you that actually we've changed our assumption of risk form for foreign travel to include travelstate.gov, the warnings that they will put out for the specific area and country you're going to, and the Centers for Disease Control, CDC, for the warnings that they put out there, because actually we've seen court cases, we both read court cases, where they specifically said these were warnings that the CDC put out there and you did not list them. So a lot of information on assumption of risk forms. Rich, really appreciate your time. A lot of meat in this subject. If you're using assumption of risk forms, you need to make sure that they are looked over by an attorney. You need to make sure that it does include these items that we talked about. And, you know, I will tell you, have foreign liability, have foreign automobile liability. You need to do this before you're doing the foreign trips, but you should have, if you're going to a camp, have parental consent forms. You should use assumption of risk forms, but you need to make sure that they're done right. We appreciate your time. We're out of time today, but we appreciate your time. If you have any questions, be sure to ask us. You can go to our website and ask us any questions. Rich, once again, thanks you for your time, your knowledge, and thank you for looking at over all those cases, because actually I only get to read one or two that you find enlightening for me to read. But I appreciate you going through and being so thorough in looking at all these cases and keeping the church and charity world informed about this.
Thank you, Jerry.
Thanks, Rich.